If you've got a disability and your reasonable accommodation's been pending for months while you're still being dragged back into the office, I want you to watch this all the way through and send it to the nerdiest person in your office. Also, if you want written information on this, because we're going to do a deep dive, feel free to check that out. We put something together for you at fedlegalhelp.com/delay. So this might be a little bit longer, but I'm going to walk you through the actual legal framework as I see it for when delay itself becomes an unlawful denial of an accommodation. With a regulation, the case is not vague, feel-good nonsense. That said, most of you facing a delay should contact an attorney if you can afford it. If you have a good case, the agency will have an attorney, and their goal is to eliminate the case, outmaneuver you. Just like I'd never recommend representing yourself in a criminal case, I think the stronger your EEO case, the more you should have an attorney if you can. That said, we're going to do a deep dive into this, but this is legal information, not advice, and I think you'll understand a little bit more about how complex this is. So let me ground this in what's happening right now. At HHS, CDC shut down its own accommodation system. Everything got centralized at the department level. There are roughly 3,300 pending requests, and HHS is saying it may take 6 to 8 months just to work through that backlog. At the same time, CDC employees are being told telework should not be used as an interim accommodation. So while your request is under review, you're told report in person or burn your leave. Some folks are being told telework isn't even available as a reasonable accommodation anymore. All this is happening while people are working in a building that literally still has bullet holes from a recent shooting. Now, here's the law under the Rehab Act and its ADA standards. Agencies have to provide reasonable accommodation to qualified employees with disabilities unless it would be an undue hardship. That comes out of Section 501 of the Rehab Act and the parallel ADA provision at 42 USC 12112B5A. And it's not just about the final yes or no. The EEOC's Reasonable Accommodation and Undue Hardship Guidance, Question 10, says employers must respond expeditiously and that unnecessary delays can result in a violation. There's also a regulation, 29 CFR 1630.203, that talks about the informal interactive process. When employers simply don't engage or they drag that process out, that itself can be part of the violation. EEOC has laid out 5 core factors to determine whether a delay crosses the line. 1, the reason for the delay. 2, the length of the delay. 3, how much you and the agency each contributed to it. 4, what the agency was actually doing during that time. And 5, whether the accommodation was simple or complex to provide. Those are the levers. When I'm looking at a case, I'm mentally running through those 5 to help determine, is the delay unlawful? So I'm going to put some meat on that with actual cases so you can calibrate your own situation or try to. So the First Circuit in Valle Arce versus Puerto Rico Ports Authority said flat out that unreasonable delay can amount to a failure to accommodate. In that case, the agency dragged its feet for months, didn't follow its own reasonable accommodation procedures, and then eventually gave her something that she didn't actually want or match what she needed. The court said a jury gets to decide if that was a denial. Body down in the 11th Circuit, a condo association sent a request for an emotional support dog for more than 6 months. No real decision, just repeated demands for more documentation. The court said, look, an indeterminate delay has the same effect as an outright denial. That's the phrase I want in your head. An indeterminate delay equals constructive denial. Now look at what the EEOC has done with federal agencies specifically. Here are just a few examples of cases. And Patricia W. versus Nielsen, DHS, took almost a year to get an employee the equipment she needed to effectively telework: ergonomic tray, mouse, software training. That delay hurt her performance and led to discipline. The EEOC said that's an undue, unlawful delay. And Ronnie R. versus Azar at HHS, an employee with a serious knee impairment waited about 3 months for an ergonomic chair. The delay was caused by confusion and ignorance of the accommodation process. The EEOC said 3 months for something that simple with no good reason is too long. That's a denial. And Doria R. versus Cordova at NSF, an employee with stage 4 cancer requested more telework in February and didn't get it until November. Each commute risked exacerbating her condition, potentially leading to paralysis. In Michelle G. versus Lou at the Treasury, it took 18 months to give an employee with attention deficit disorder a quiet workspace. Managers knew she needed it. Instead of acting, they just kept issuing negative performance feedback. EEOC called that an egregious delay. In Yasenua H. versus McDonald for the VA, it took nearly 4 months to provide appropriate lighting to help with migraines. The fix wasn't complicated. There was no good explanation. Again, violation. In Lagania versus Clinton at State, a legally blind passport specialist asked for a large print keyboard. The agency essentially did nothing 4 months, then took nearly 15 months total to get it for her. EEOC held that up against its own guidance example and said this is exactly what not to do. There was an unnecessary delay violation. On the flip side, there are cases where delay wasn't treated as discrimination because of how those 5 factors played out, which is why it's hard to say what will happen. One of the cases, complainant versus McDonald, the 56 delay in getting a larger monitor was described as not commendably efficient, but the EEOC stopped short of calling it discriminatory. In Barham versus Geithner, there was about a 5-month delay for an employee who reacted to a coworker's perfume. The agency was effectively trying interim options, different workspace fans, telework, conference room space, and the employee rejected some of them. The EEOC found no violation because they were actually working the problem. In Smith versus Shinseki, a nurse wanted reassignment to a midnight shift. It took 21 months, but all the midnight positions were filled. EEOC said the agency didn't have to bump someone else to create a vacancy, and they let her work relief night shifts in the meantime. So given all that context, no undue delay. Another example, Rabi versus Rice, the State Department was trying to hire a reader for a blind employee. He insisted on being present for interviews and adding higher qualifications. That contributed significantly to the timing the EEOC found and said basically you helped create the delay that matters. So when you put all this together, you see the pattern. Short delays with real reasons and real interim accommodations, often okay. Longer delays where the agency is moving heaven and earth and part of the holdup is outside their control, sometimes okay. But months-long delays for simple things, no clear explanation, no interim help, and the employee is getting sicker, punished, or pushed in the meantime, that's where the EEOC and the courts consistently say this is no longer processing. That is a denial. So now plug HHS into those 5 factors. Length of delay, I don't know, you could argue they're already predicting 6 to 8 months in addition to whatever has already occurred to clear a backlog of roughly 3,300 requests before you even factor in new ones. Reason for the delay, this is largely a self-created bottleneck from centralizing the program and imposing new telework limits, not a hurricane taking out a facility. They're a very rich organization. Seems they could come up with money somewhere. Employee contribution, virtually none. They're the ones being told to hurry up with the questionnaires and medical documentation under tight deadlines. What the employer is doing during the delay, instead of meaningful interim accommodations, some components are saying telework should not be given as an interim accommodation and telling people to come in or use leave, even in a building that was just sprayed with bullets. That could be a huge factor in my mind. Complexity, you could argue many of these are straightforward telework equipment or scheduled modifications provided in past with no problems. Exactly the category cases where 3, 4, 5 months of unexplained delay has already been found unlawful. So this is me walking through some of the factors so you can see that. This might switch up based on individual cases, and I'm not giving you legal advice about your specific situation in social media. That would be irresponsible. But as a general matter, when you line up the facts against the regulation, the guidance of this line of cases, you can see just how legally risky this is to wait 6 or 8 months in the office. So if this is you, here's what I want you to do. Think about your dates. When did you first request accommodation? When did they ask for documentation? When did you give it to them? What, if anything, have you offered in the meantime? Say the memo is telling you telework isn't allowed, or that your request will be closed if you don't jump through hoops in 7 days. Well, they give themselves half a year. And if your health, your safety, your career is being put at risk while you request wait its turn, I think especially then you should talk to a qualified attorney who understands federal disability law and can help you assess and try to imagine what future outcomes might be. If this has helped, please share it with a coworker. This is, again, much more detailed than usual. Shows you a little bit of behind the scenes about what we do as lawyers. If you want to see some more information on this in writing, might be a little easier, go to fedlegalhelp.com/delay. Otherwise, as always, thank you everybody for your support. Take care and have a great day.